Welcome back, everyone. We're going to start your afternoon session. And now we have the platform work and unions. And to act as president of this session, we have the honor to invite the Master in College and Fundamental Rights by Universidade Metodista de Piracicaba, PhD candidate by Universidade de São Paulo, Specialist in Constitutional Law by Pontifícia Universidade Católica de São Paulo, author of books and professor, the Labor Public Prosecutor, Your Excellency, Mrs. Carolina Marzola Irata Zedes.
Ladies and gentlemen, distinguished guests, friends and colleagues, good afternoon. And it's a distinct honor to serve as the chairperson of this panel. This panel named Platform Work and Unions. Well, before we commence our proceedings, I would like to express my gratitude to all the participants, to the organizers, especially Professors Freitas and Calvo, and who have contributed to the success of this event. Throughout this section, we will have the opportunity to delve into the cutting-edge research and engage in insightful discussions. First of all, I invite to this panel, to join this panel, Mr. Samuel Streicher, who's right here, and Professor André Zipper. Well, welcome, professors, and I kindly ask for permission to read a brief curriculum of the speakers. Professor Samuel Streicher is a professor of law at New York University School of Law, director of its Center for Labor and Employment Law, and co-director of its Institute of Judicial Administration. He received his AB from Columbia College, his MS from Cornell University, and his JD from Columbia Law School, where he was editor-in-chief in the Columbia Law Review. Streicher is also a member of the arbitration mediation panels of the American Arbitration Association and Center for Public Resources, and is a fellow of the College of Labor and Employment Lawyers. He has been recognized in Human Resources Executive, Super Lawyers, and Best Lawyers in American publications. Professor André Zipper is a labor lawyer, PhD in law, from Catholic University of Paraná, researcher USP-GETRAB, professor, member of the National Labor Law Committee at Brazilian Bar Association. So,
Pode só exibir o PowerPoint em tela grande. Não está aparecendo lá.
Posso dar início? Pode? Pode? Tá. So with that, I declare the section officially open, and vamos, peraí, aqui, ó. Peraí, Dri.
All right, folks, may I start?
Yeah.
Right,
Okay.
I'm honored to be here, honored to be a guest of the university, very fine, well-known international university and law department. And we've gotten to know Professor Freitas and his very talented wife, very highly regarded mediator. It's a great pleasure to be here. Now, you know, law is very culture bound. It's very hard to do comparative law, because law comes out of this society, comes out of the culture. So, you know, whatever I say, I have my American hat on. my United States hat on, and it may not be all that applicable to your situation. But I think this topic is applicable to your situations. The topic here is, what do we do with these platform workers? Which I was telling Professor Freitas is not such a new idea. We used to have Shape Up. Have you ever seen the movie On the Waterfront? People would show up at the piers. There might not be a job for them, but they'd come if there was a job, and they usually had to be on good terms with the union, or there wouldn't be a job. That was the old gig work, but there was gig work. There's always been gig work. The difference now is that because of technology, it is easier for the user companies, I call them user companies, to leave open whether they're the employer or not. But it's easy for the user companies to basically accomplish their objectives electronically without actual on-site supervision of the workers. That's the change, the big change with respect to gig work. So it's not so much the on-demand aspect of it, but it is the fact that management does not have to closely monitor these people. All right. So what my topic is platform workers, gig workers, and the antitrust laws. This is important in the United States because the antitrust laws have historically been invoked against labor unions. Now there's been a change in sentiment under the Biden administration, but the general view is if two or more competitors get together, that's a per se violation of the antitrust laws. So historically, unions have had a lot of trouble with the antitrust laws, but over time they got flexibility, which I will talk about. So why is this topic important? The topic is important because I'm talking about what gig or demand workers can do on their own without waiting for the government. It's very hard to change legislation in the United States, but also here in Brazil. I know you've got a new premier, but he's also going to have trouble changing legislation. He's got a very thin majority, as I understand it. And that's a healthy democracy where there's a thin majority, but it means it's very hard to change legislation. So I'm not talking about legislation. You know, who knows? Maybe another Vargas will show up and you'll have a new edition of the labor code. I know Vargas has a negative reputation a little bit, but I'm talking about the non-dictator Vargas, the man who designed the Brazilian labor code, designed the Brazilian labor courts, the very institutions that you all know extremely well. So one reason this topic is important is I'm talking about what gig workers, platform workers can do on their own without waiting for federal legislation. Secondly, I think it's more tailored. We can have a more tailored response to gig workers than bringing them in under the definition of employee in which all aspects of labor law and employment law apply to them. For one example, one of the main reasons that the Lyft and Uber companies are resisting employee status for their drivers is because we have overtime laws that are very hard to fit for what these drivers do. They spend a lot of time waiting. How do you count that time? I think it's solvable, but it's not solvable by saying you're automatically employees under the labor laws. This is more tailored than that. And Professor Freitas will tell you that in some countries like Canada, there's something called dependent contractors. This is a way to accommodate dependent contractors too, without bringing them under the full shelter of the labor laws. Because there's a difference between these workers and traditional workers. And it's not fully captured, I think, by the Brazilian concept of domination. What's the phrase you use? Dominated workers? Subordinated workers. It's not fully sure. There can be workers that fit that definition, but very often I find I do a lot of my sociology in the streets, in the cabs, in the Uber, in the Lyft, and also I get to learn about why they're doing what they're doing. Many of them like the work they're doing because they pick their hours. That's a wonderful thing. You pick your hours. And you use your own car. if you want. The car doesn't have special placards on it that can only be used for business. It's your personal car, and you use it as well. You get insurance. I know this is contrary to the usual concept, but I think it's a reality you have to encounter. And some of them actually have more than one car, and they hire people to do the cars for them. Now, they're still driving cars. You know, they're not like us. We love our work. We're brain workers. We're professors. We're lawyers. We run the bar association. It's not our kind of work, but there is an element of freedom in their work that is not true of factory work. My father was a factory worker. He had a back problem. They wouldn't give him a chair. So he retired at 62, which was the earliest age for Social Security. I say, Dad, why are you retiring? You have no friends. You don't play golf. You have a bad back. Why are you retiring? And he said, because they wouldn't give me a chair. That's the reality of industrial life. This is a very different kind of reality. That doesn't mean it doesn't have problems, but it may mean a different approach is required. Also, as non-employees, they get a gift. We have a preemption doctrine in federal labor law where the state and local governments can't touch anything involving collective bargaining, labor organization, even if they don't have unions. Right now, there's an attempt, I think in California, maybe Professor Fisk has mentioned to you. By the way, California is the best place to live, to work, to get fired from, and to be a lawyer in. I once told, I was the chief reporter of the Restatement of Employment Law, and I had a bunch of advisors from all different sectors of society. One of them was Cliff Pilevsky, who's a very highly regarded plaintiff side employee lawyer. He has a yacht because he's in California, he's making extremely good money. So I said, Cliff, do me a favor. I'm going to quit my tenured position in New York University School of Law. Let's go around the country. Let's go around the country and lobby for the British wrongful discharge legislation or the French wrongful discharge legislation. This is what Cliff said to me. Who says I want the British wrongful dismissal legislation? Who says I want the French wrongful dismissal legislation? I want California law for everyone. Okay. Anyway, so there's a little bit of we've gone down a tort system, civil action system in our employment law. It's very hard to get off of it. I think if you ask people today, employers and employees, they would prefer a labor court system, but you can't go. We call it path dependency. You go down one road, it doesn't connect up with the other road. It's the way law develops. In any event, because they're not classified as employees, they can actually get help from the state and local governments, state and local legislatures, without triggering federal preemption. And the state and local legislatures now are much more pro-worker than they were historically, much more liberal than they were historically. So it's possible to get the state law to protect you from discharge, to protect you from dismissal, and at the same time engage in collective bargaining. So I think it's relevant. It's another way of thinking about the problem of platform work and gig work, and that is to allow them to organize and form unions and bargain with the user companies, with the help of state law. All right. We have a new antitrust law. I'll tell you about the old antitrust law in a moment. We have a democratic administration. See, in the United States, I know the Latin American model is that you have the prime minister there, the premier there for 4 years, then he applies for another 4 years, and then his soulmate becomes the premier of the country. It's the Peronista model. I'm not getting any laughs here. You understand what I mean? Evita and Perón's second wife, and then Mrs. Kirchner, because you have this two-term limit. In the United States, we have a real two-term limit. President after FDR was very popular. He steered us through World War II. And, the country was very isolationist in the beginning. They didn't want to deal with other countries. And he lent his ships and his tanks to Britain under the table, under the waves. Very popular president. But by the fourth term, he was completely senile. And he almost appointed a person very favorable to the communist way of thinking as his vice president, who would have become the president, Henry Wallace. Henry Wallace. After the Constitution was amended after Franklin Roosevelt to say only 2 terms, we still don't have the phenomenon of the wife. I think Hillary wanted that role. Hillary Clinton, after Bill Clinton's 2 terms, she ran, and believe it or not, she was not able to beat President Trump. She was a weak politician, very smart woman. In any event, we now have a new antitrust because the Democrats have put in a Columbia law professor named Lena Khan, and she has a very pro-worker point of view of the antitrust laws. So, for example, they blocked the Random House merger, publication company merger, because it would have meant 1 fewer buyer of manuscripts, might hurt workers. And the agency is called the Federal Trade Commission, and they're proposing also to outlaw all non-compete clauses across the country. We don't know what the future is going to bring. First of all, President Biden has to be reelected, and that's an open question right now. I will tell you what's going to happen 30 years from now in the United States, but I'm not going to tell you what's going to happen next week. You know why? I don't want you to tell me I got it wrong. 30 years from now, I don't know if I'm around to hear your criticism. So who knows what's going to happen with the FTC. But right now, they're taking a much more pro-labor point of view. Historically, the FTC did not like independent contractors getting together and saying that these are our prices, our wages. We're going to divide up the territory. These were per se violations of the antitrust laws. But now there might be a change. Who knows? Generally, the point of view, the old labor law, the new labor law is pro-worker, pro-labor. We'll see what happens. That's the new antitrust law. Pro-worker, pro-labor. We'll see what happens. It's early days. The old antitrust law took the view that if 2 or more competitors, and they viewed employees as competitors with each other, in a very limited sense, are they competitors with each other? But the purpose of the labor union, as it is here, was to take competition out of the labor market. So workers are not going to compete with each other with respect to wages, hours, pensions, and that sort of thing. Instead, the union would set these terms and would outlaw competition between workers. That's the objective of the union in the United States. It's still the objective of the union. So historically, there was very aggressive application of the antitrust laws against unions, against union strikes, union picketing, secondary boycotts. So unions not only strike their direct employer, but they try to strike other businesses that do business with the direct employer. It's called a secondary strike. The Teamsters were very good about this because the Teamsters were the truck drivers union. They're still strong. And basically they would enter into agreements with other unions. So I am making underwear. I'm an underwear manufacturer. You remember what underwear is? It's still a real product, I think, even here in Brazil. It's a necessary product, I would say. I'm making underwear, and the union, my workers are striking me. And I say, I could care less. Let them strike me because I will get my underwear from my New Jersey fellows, my New Jersey factories, and I'll bring them into the market. And what the union was able to do by alliances with the truckers union and other unions, they would not deliver the underwear from New Jersey in order to put pressure on the direct employer. See how powerful that was? It's called a secondary boycott. And when the unions would picket a store, they would picket, they'd say, we want to picket because you're not paying union wages. And meanwhile, the other unions out there in the country, in that market, would honor the picket line, which would mean that even though I'm a bakery worker, the union wants to organize me, they can shut me down because I can't sell the bread. I got the bread. Bread goes stale very quickly, as you know, right? Even with all the gadgets we now have, and aluminum foil and plastic bags and sprays and all that, bread goes bad. So, and they're not letting me ship my bread, deliver my bread to my customers. So that was also the recognitional picketing. So what happened initially in the United States, I'm saying up until the 1940s, was very aggressive use of the antitrust laws against labor. Even though, unions are not big players in the product market, they're not the manufacturers themselves, but they took a view, almost an ideological view of the antitrust laws. They still have this view to some extent, by the way. If two or more competitors get together, no matter, even if they have no market power, it's a per se violation of the antitrust laws. It'll maybe change, who knows? Then we have something called yellow dog contracts. So you know this because you come from the Brazilian labor code experience. Usually a worker who's about to be hired is in love. Because we Americans like to work. I think you've heard from my co-author how you have to work to get health insurance and all that. People want jobs in the United States, which is a good thing. It's good. My father was a factory worker. It didn't bring him a lot of happiness, but he brought home a steady check. He was able to have a family. There was food on the table. It's an important part of true liberty to have a job. Workers, when they're seeking work, will sign anything because they're in love. Do you understand that? When you're in love, you don't ask questions. Now, it's true the employer doesn't want to hear any questions. I'm making a little bit of a joke. So they signed contracts that said that they would never form a union. They'd never talk to other workers. It's the very same thing that's going on in China today. But China doesn't do it by contract. They do it by the fist. I know I'm losing my audience in English. They use the hammer. You saw the hammer and sickle of the communist design? The hammer was to force these workers into submission. That's the true communism in China, the true communism in China. They have no right to work in these businesses. They have no right to even be where they are. 15% is taken out of their pension. Where does it go? Who knows? They have no right to be there. The law in China says 6 months severance pay if you're laid off. They go to the employer and say, pay me my severance pay. And the employer says, who are you? Because unlike the Brazilian law, there's no record of these workers working for the company. So they go to the media. I know this is a tangent. I'm sorry. I'm just pointing out the other countries have problems too. They go to the mediation tribunal. 3 years, nothing happens because the judges won't. It's not like the labor courts that we have here. The judges won't do anything until the party boss says you can give them some money. So after 3 years, they give up. And that's the reality of the Chinese court system. But we had something like that in the United States as well. We had they were called yellow dog contracts. You sign these contracts because you're in love. You'll sign whatever the employer tells you to sign. And then the union would try to organize these workers, and the company would go into court and get an injunction against these workers, against the unions. The unions would be in jail. With an injunction, if you violate the injunction, I don't know, maybe Trump will figure out a way out of this. But usually if you violate the injunction, they put you in jail. It's called contempt. No jury trial. All right. So I think, and the remedies were treble damage at 3 times economic loss, plus imprisonment if you violate a court decree. Now I want to introduce to you. Can I get rid of this thing here?
It's not working there.
Okay. There are 3 brilliant short people. Now, let me tell you, God made me short. And I'm very grateful for it because he gave me a sense of struggle in my life. I was on computer dating before I met my wife, after my late wife died. And I had a woman, and she said on the phone, why are you short? And I said to her, I've been asking God that question every single day of my life. I don't know why she asked me that stupid question, but I was glad she did because I didn't have to take her to dinner. That was the end of that date. But there are 3 brilliant short people who are, I call them they are the American Vargas. I'm using Vargas without the dictatorship. Because, for a time there, he stopped the dictatorship, he ran for office and still got elected. Brilliant guy. A brilliant guy. People say he's the most effective, productive premier of Brazil. Who knows? Maybe Lula will become the new Vargas. I have no idea. He's through with his corruption trials. I think he has a bright new future. Premier Vargas has very few. Here are the three guys. The first guy is Samuel Gompers. He comes to this country. I forgot where he came from. I think it was Russia. He was a cigar maker. In those days, we must have made good cigars. We don't make good cigars anymore. We smuggle them from Cuba. Everyone is they have some leaves from Cuba. They grow them in the south of the United States. Nothing is as good as a Cuban cigar. Very often when I'm in another country, I bring Cuban cigars with me, and then I get scared that the customs people will see me, and I throw them in the garbage can. But he was a cigar maker, and he was the first president of the American Federation of Labor. We have 360 million people, official people in the United States. We're an enormous country. I know Brazil is an enormous country. But we're also an enormous country, all different kinds of people. Some of them are agricultural centers. Some of them are places where you ride horses from place to place. It's very hard to organize the country, but actually Samuel Gompers did, because he organized by skill. People were organized in their crafts. So if they were a carpenter, they were organized by skill, and they were not asking for permission from the workers to represent them. They were there to represent the workers with or without their permission. A little bit like the Brazilian system. But not by law, because Gompers couldn't trust the law. Every time he passed a law, like for, only 10 hours of work a week, right? 10 hours of work a day, 35 hours a week, 60 hours a week, whatever he got through the legislature, the state courts at the time struck it down. So he decided, makes no sense to go through law. He had all these other unions, socialist unions, cooperative unions. He said, count on yourself. Called it voluntarism. Count on yourself. But the idea that he had, I call it Gompers 101. The way a union survives is by organizing the competition. So all the competition in that sector are under the same standards, not by law, but by organization. So people talk about the great period of American history in the mass production industries. The reason for that was we had very few producers. We had 3 or 4 producers of cars. The international market had not yet come to the United States. And what the union did is they organized the 3 producers. And once you organize the competition, the producers are pro-labor because they're not worried about being undercut by the competition. Now, other countries try to do that by law, but law is always very uneven enforcement, as well as even in Brazil, the halcyon Brazil days, I'm told that 35% of the gross domestic product is in an informal labor market. I don't know how it's counted. Professor Freitas has assured me that the statistics are very good. Remember, you told me that in the car. All right, so that's Samuel Gompers. Let me go to the second brilliant short person, Fiorello LaGuardia. He is the most prestigious graduate of my law school, NYU School of Law. They had a night school there. He was a congressman from Spanish Harlem. He was an Italian Spanish Harlem. He was four terms mayor of the city of New York. Franklin Roosevelt made him the director of mobilization, domestic mobilization during World War II. And the reason I bring him up is that he is the author of the Norris-LaGuardia Act, which was a very important statute for taking the antitrust laws off the backs of the unions. Norris-LaGuardia statute. Now, I want to be called the Norris-LaGuardia professor, but the professor who has that chair will not give it to me. So I've been plotting his demise, but it hasn't worked yet. Because I'm proud of Fiorello LaGuardia. The Norris-LaGuardia Act, which basically said no federal injunctions in labor disputes. And labor dispute involved any situation where any employers and employees are in a dispute. And we've proved in our article that in 1932, when the Norris-LaGuardia Act was enacted, they used the word employees and contractors interchangeably. They were not thinking of common law employees. So we base a lot of our article on the Norris-LaGuardia Act. Then the third short, smart person. 12 people have a right to live. Don't get me wrong. I take nothing away from tall people. I'm just saying, I want to cavil, as it were. I want to delight in the greatness of these 3 short men. The third was Felix Frankfurter. Felix Frankfurter was the guru of the American left wing. He was the professor at the Harvard Law School. He decided which of his students would become clerks on the U.S. Supreme Court. He actually wrote the Norris-LaGuardia Act for LaGuardia and Norris. Very active. He's a little bit like Professor Freitas. He's everywhere, like Professor Freitas, Professor Frankfurter. He was also an advisor to Franklin Delano Roosevelt while law professor. And after Franklin Delano Roosevelt made him a justice on the Supreme Court. Today would be unheard of, but he was there all the time giving Franklin Roosevelt advice. So why do I bring up Felix Frankfurter? First of all, he wrote the Norris-LaGuardia. Number two, he wrote an opinion, 1947, United States versus Hutchison, that said, labor cannot be sued under the antitrust laws, civil or criminal. Excuse me? Sherman Act, and yes, he did it by judicial decree. He said, you take the Sherman Act, you take the Clayton Act, you take the Norris-LaGuardia Act, and you put them all together. It's like a mix in a soup, and you can't slice it up. It's one message. The message is, if labor acts alone, if it doesn't combine with business groups and engages in traditional labor protest activity, it cannot be sued under the antitrust laws. So Sam Gompers, when he got to the Clayton Act, there was a provision called Section 6 of the Clayton Act, still the law. And he said, this is the Magna Carta for labor. He knew it wasn't. But like St. Paul, he was very good at marketing. Because he knew, who knows what it means? Labor shall not be an article of commerce. What does that mean? That's what it says. But Frankfurter, 1947, said, we have to treat this as a holistic body of law. As a holistic body of law, labor cannot be sued under the antitrust laws, civil or criminal, if they act alone. This is called the so-called statutory exemption. If they act alone and they engage in traditional labor protests, which includes strikes, picketing, indefinite picketing, secondary boycotts, hot cargo agreements. Now, jurisdictional strikes. Now, what happened after the war is that we had all the unions, including the communist unions. We had communist unions in the United States, but for a while there, they were striking because there was a period in which, the workers' state had made an alliance with the Nazis, the National Socialist regime, a no aggression pact. And so for that year and a half, the communist-led unions in the United States struck, but every other union made a promise to FDR, no strike. And then after Nazi Germany invaded Soviet Russia, including the communist unions, no strike. So they had no strike during the war period, which is a period of inflation. They had an anti-inflation board, but you put a lot of pressure on the economy, everything's more expensive. So in 1946, after the war, there was an enormous strike wave all over the country. And in the 1947, 46, 47 elections, the Republicans, for the first time, are in control of both houses of Congress. For the first time, because when under FDR, he ran the government. He had a veto-proof Congress, House of Representatives, the Supreme Court involved, had his friends there, like Felix Frankfurter. He appointed almost all of them. In the beginning, he tried to pack the court, but he realized all he has to do is scare them into retiring, and they retired. Then he brought his people on. They were all his advisors and his friends. He practiced law with them. So he had a lot of power, but in 46, 47, lost control of Congress because of the strike wave. And in 1947, Congress passed something called the Taft-Hartley Act, which outlawed the secondary boycott, still outlawed jurisdictional strikes, or regulated them, and outlawed indefinite recognitional picketing. Harry Truman, who was FDR's vice president, who became president. By the way, FDR did not like Harry Truman because FDR was, he went to Columbia Law School, but he flunked out but he had a very high opinion of himself, Franklin Roosevelt. And he said Harry Truman is just a haberdasher because he ran a furniture store. So he had low regard for Harry. He was a very great president, by the way. Harry Truman vetoed the Taft-Hartley Act. He called it the Slave Labor Act. But the Congress overrode his veto, because we can do that in the United States. If you can get 2/3 of both houses, they can override the veto. I told you this was a Republican takeover. But the difference between the Taft-Hartley Act and the antitrust laws is the penalties are regulatory penalties. You have to still go through the National Labor Relations Board to get an injunction. Generally speaking, it was a much more even-handed approach to this secondary boycott problem and the hot cargo clauses. Okay, I'm giving you a little history here. So we have two exemptions from the antitrust laws. One is the statutory exemption, because it's based on Sherman, Clayton, Norris LaGuardia, and it's what Frankfurter said. If labor acts alone and it doesn't have combinations with business groups, even if they're trying to drive you out of business, there's a case called Hunt versus Crumbach. I have the citation here in my PowerPoints. Professor Freitas is directed to give you all copies of my PowerPoints, which also he's directed by me, because ordinarily I'm his servant. Right now, he's my servant. I'm very honored to be your master for a short period of time, pro tempore. He is to give you my PowerPoints, but also have my information, how to reach me. Hunt versus Crumbach in 1945, the union hated the company and they drove it out of business. And the Supreme Court said, still protected by the statutory labor exemption, because all they were doing was striking. And the rule is, if you're not in combination with business groups, even though you have a very bad motive, your bad motive is to drive this company out of business because you don't like the company, it's still non-antitrust exempt. So in theory, the union can burn down the factory. It won't be sued under the antitrust laws. It still can be sued under the criminal laws, right? And it can still be sued under tort law, right? But it's very hard to sue a union in those days because they didn't have yet legal personality where they could be sued as an individual, as a unit, as an entity. The Taft-Hartley Act changed that. So it used to be hard. That's why they didn't incorporate. The reason unions didn't incorporate, and they're just associations, is because they didn't want to be easily sued, because they knew the courts didn't like them in those days. Things change, of course. My point is they could burn down a factory and still be exempt from the antitrust laws if they're using traditional union methods. You know, how does a factory burn using traditional union methods? You know, you leave the plant, you know, that you should have shut down the molten furnaces, you know, but you forgot, you know, things can happen. Things can happen. Can you prove it was intentional? Not that easy. We also have a non-statutory exemption, which the courts developed, and that's to protect collective bargaining. So if the companies get together with unions, and unions want to have multi-employer bargaining, it's still the Gompers 101 message. They want to organize all the product market competitors, because when they do that, the companies can live with the union, because the costs are all going to be borne by the same industry. Now, I don't know if the unions here do that, because we'll talk about Brazilian unions if we want to. My thinking is they have taken the teeth away from the Brazilian unions. Vargas, you have to remember, brilliant guy he was, did not want to see communist takeover here in Brazil. So he wanted to have the class conflict in the room so that, you know, good mediators could be there, like Professor Freitas's bride. They can be there and it can solve the conflicts. But, you know, when you put a union, and I'm just speaking now from my point of view, you put a union in charge of, first of all, there's no election. There's no election, even though the union told us there's elections. We went and visited the metal union, by the way. What's the name of that area? San Bernardo. Brilliant, wonderful people. They had pictures of Che Guevara. They had pictures of Frida Kahlo. They say we like to display the revolutionaries. I said, Frida Kahlo, the closest she got to revolution is when she was sleeping with with Trotsky. That's the closest she got to revolution. But, you know, Diego Rivera was her boyfriend, and she's very popular in the United States as well, by the way. So she's there, and Nelson Mandela's there, and Che Guevara. All these pictures are there because it's the CUT image, But they're very able people. But I don't know what they have to do because the labor code does a lot of what they do. They are now in charge of 19 different companies and their employees. It's pretty hard to travel in Sao Paulo, even in this San Bernardo area. They can't get around to all these workers and see them. It's a different kind of union movement. And that was Vargas's intention, in my view, because the union movement and the peasant movement, they were dangerous. Vargas was into, I think this is my assumption, the assumption behind corporatism is to defang the labor movement. I mean, that was its purpose. Now, we tried corporatism even in the United States. Franklin Roosevelt's first administration, he didn't know what to do. 1/3 of the country was without work. People were sleeping on the streets. It sounds a little bit like New York City today. They were sleeping on the streets. They were sleeping near the churches, like, a little bit like Sao Paulo. They're sleeping near the church. He didn't know what to do. So he borrowed a leaf from the Italians, as did Vargas, by the way. And we had something called the National Industrial Recovery Act. Basically, labor, management, and the government were all in the same room, and they were going to negotiate codes of fair competition. So there was a code of fair competition for kosher butchers. It's called the Schechter poultry case. They somehow got involved in suing the government for this scheme. They violated the poultry code. By the way, if you comply with the poultry code, they put a blue eagle on your shop. So it's called the Blue Eagle regime. The Supreme Court said even Frankfurter went up to FDR and he said, this smells too much like fascism to us. It's like there's no control on what these committees can do. If you want a code of unfair competition, you can do that. But a code of fair competition, what does that mean? So it was struck down almost 9-0 by the Supreme Court. So they had to get rid of that method. And they brought in the method of the National Labor Relations Act, which has been very influential throughout the world. So you have to have a non-statutory exemption when the companies get together with the union. So you have all the employees. This is the Gompers 101 dream. All of the competitors at the same table with the union. You need to have an antitrust exemption there too. So as long as you're not fixing prices, and you're not trying to have a monopoly of a particular producer, that's also protected by the non-statutory antitrust exemption. All right. Now let me give you about we have the citation here, but it's been blocked. It's okay. Oh, the citation is at the bottom. This article I will send to you. If you send me an email, I will send you this article. Just promise me the following. If you like it, cite it favorably. If you don't like it, cite it unfavorably. The worst thing you can do to me is ignore it. Understand? I'll give you the article. You'll know what you have your own rules I'm giving you. All right, this is our approach. Our approach is that the labor antitrust exemption applies however you are classified by your employer, however you are classified under employment law. One has nothing to do with the other. So even though the company is classifying you as an independent contractor, they can classify you as the blue man in the sky. It does not affect your antitrust exemption because the antitrust exemption applies to all laborers. Remember Section 6 of the Clayton Act. The labor of a human being is not an article of commerce. So what Sam Gompers did as a marketing ploy has now become the law. Laborers cannot be sued under the antitrust laws. So even if you are classified by your employer or by state law as an independent contractor, you can still get together and organize and strike and not be enjoined. This is our approach. A brief was done with my views in Seattle. It's a big honor when very good lawyers say, brief of Samuel S. Stryker. First of all, they're citing me, and they're telling the courts I'm worth listening to. Sometimes I have to pay for this representation. No, just kidding. But this was in the Uber Lyft case. There's a case in Seattle. The Seattle, remember now, because they're not employees, there's no federal labor law preemption. They can make alliances with state and local governments, including New York City. New York City is one of the biggest now labor supportive municipalities in the world. When you can't get something in collective bargaining, you go to New York City Council and they give you what you want. Completely different from the old Gomper's view in which we do it by ourselves. Instead, they go to New York City Council. So it doesn't matter what your classification is. You're free from antitrust labor. As long as you're a laborer, you're free from antitrust responsibility, civil and criminal. The only question is whether you are a laborer, which brings us to the next point. What is a laborer? This is from our article. You know, I should be called the Samuel Gompers of the gig worker. I'm short. I'm smart. Why not? I also like Cuban cigars. Why not? All right. This is the definition. Are you principally supplying your labor services, your personal services? Okay. There are only two steps to this, without making significant capital investments. Okay. We say, and we base this on the history of the American labor movement, just because you bring your tools to the workplace, that doesn't mean you are making a capital investment. Your tools are also used in the home. When your husband wants you to fix the door, you got to get out the hammer, the screwdriver. The same tools are being brought to the work. Historically, American workers brought their tools to work. Why? It would make no sense for the employer to make an investment in this we call it fungible, general purpose investments. So too with a car. You bring your car to work. You also use it on weekends to take your daughter to wherever she wants to go, because your daughter is running your life. As was true of my daughter, as is true of Professor Freitas' daughter. Running your life because you want them to be happy. At some point, you have to say no. But you beg that, you hope that your wife will support you in this no. Anyway, I'm in love with my daughter and my son. I'm just saying that we all spoil our children. So that's it. You provide principally your labor services without making a significant capital investment, and these general purpose tools are not capital investments. You don't have to go to Congress to get permission. Our article is based on existing law. The law reviews were not interested in, and we got published ultimately by a very fine law review, but they're not interested because it wasn't theoretical. I don't want to do theory. I'm a practical lawyer. I was in a PhD program at Cornell. I decided if I stay in this PhD program, I'll be doing this for the next 15 years. I want to become a lawyer. This is something I want people to do on their own and for courts to allow, or we stop them. You understand what I'm saying? I'm not asking for Congress to do anything. It's very hard to get Congress to do anything. We have two parties. They're very close. You know, we got a filibuster rule. You know, it's very hard. It's very hard to get your parliament to do anything. Lula is going to have a lot of trouble. I don't know what he wants to do. So far, I'm not hearing a thing from Lula right now, but he is all over this plant that we went to in San Bernardo. They are the Lula party, the Lulaistas. In the same way, we have Freitasitas and Freitas sons. They are Lulaistas. Okay, so that's the definition, two-pronged. You provide principally your labor services, and you do not make a significant capital investment. And these fungible, general purpose tools are not capital investments. All right, let me say a few words about the common law on independent. We have time? Left 10 minutes? 5 minutes. Andre, do you want to speak?
No.
Andre,
My time for you.
No, you need.
We have plenty.
I don't want to take your time, Andre.
No.
Andre sat between me and my wife last night, so I know I got to be careful.
We're the last ones to talk, man. We have all the time in the world.
I'm trying to say hello to my wife, and Andre is there. Everywhere I go, it's Andre. All right, let me talk about the common law for a moment.
People are full of
Listen to me. Go ahead.
people are full of listen to me. Go ahead.
No, I want your time. Is it your time?
No.
Okay, it's his time. Go ahead, Andre. I have enough.
No,
No, go ahead.
Okay. The basic rule in the common law is a fancy word for the law that courts make without legislation. Because we came from England, you know, we took the common law from England, we took the civil jury. We're the only country in the world that has a civil jury. The English got rid of it a long, long time ago. But we didn't take the English manners. We have our own manners in America. But we have the common law. The common law is what courts make up on their own. And historically, the courts are very conservative. Now they've changed. Maybe because of the appellate judges seminars that I run. I told you, I'm the Sam Gompers of the New World. The question under the common law, and it's still very influential, is does the employer control what you do? How you do your work? That was the basic test, because the common law came out of tort law. If a worker bangs another worker over the head or a customer over the head, you can sue the worker. The problem is the worker has no assets, has no property. So suing the worker is a complete waste of time. You all understand that? I've told people in my students, never sue a poor man, never marry a poor man. But certainly never sue a poor man. It's a complete waste of time. Now, unfortunately,
That's why I'm still single.
that's why you're still single. That's why I was single for 1.5 years till I met my Abby. Okay. There were always exceptions to that. But the reason for that is if you control how the work is done and someone gets injured, you should be responsible. You are the deep pocket. And you should be responsible for making sure that the establishment is run well. There's no danger spots. Now, even historically, it was the case that people could be employees even though the work was not controlled by the employer. A chef of a restaurant, you gonna tell the worker, you gonna tell the chef how to do his cooking? No, but he's still an employee. He's still an employee, even though he's highly skilled. A doctor is a staff doctor, a surgeon, a lawyer, yes, a lawyer. So there are good examples, even at common law. I was the chief reporter, had the honor of being chief reporter of the Restatement of Employment Law. I urge you all to, it's available online. And we said reporting on where we thought the law was, the common law was. And remember, Liz said yesterday, when it comes to a question of common law, you go to S. Stryker. Remember she said that? Don't forget. I have it taped. I'm carrying tapes with me all the time now. Even if the employer doesn't control how your work is done, you can still be an employee if the employer does not enable you, does not permit you to run your own business while working for the employer. So if the employer says the trucks have to have the decal of the company and they can't be sold without the permission of the company, under the restatement definition, that person is still an employee, even though with off-site drivers, you really don't control how they do the work. Now, you can control how long it takes them, but there can be traffic. It's a very difficult thing to control. You can go visit your favorite prostitute, and, there'll be some extra mileage you can't account for, but it's very hard to control what you do off-site. As I told you, the big change in employment law worldwide is technology enables the user company to actually achieve its managerial goals without on-site supervision. In the old days, when you went to on a shift, you're on a ship, you're unloading the ships. Now we do it by containers, by the way. Pull the container and you break up the container off-site. But in the old days, you had the guys show up. This was on-demand work, but you were there to make sure they didn't break the stuff, they didn't throw it in the water. You had to be on-site supervision. Now you don't need on-site supervision by technological means. That's the new revolution. In any event, that's the restatement approach, which we believe is in the common law. The third approach that is gaining favor is called the ABC test. It's prevalent in unemployment compensation. The California Supreme Court came up with it. Remember, common law is judges making up the law. I know the labor court is never making up the law because they have the Vargas Code to work from. And they read into the law what was always there in the law. Am I right? Read into the law what's always been there. So there's a three-part test, but the important part is the so-called independent contractor doing the work of your regular employees? If they're doing the work of your regular employees, in my view, under the common law, the restatement, you're an employee, not an independent contractor. Why is that? You're basically evading the labor law there. There's no independent rationale for what you're doing. I don't care if a broker comes in and the broker is the one that pays the contractor. They're doing precisely the same work as the regular employees. So this is a very important test. I'm hoping that the labor court judges in the audience, or those of you who want to become labor court judges, think about that. Think about that. So it's not so much subordination. That's a very, very Latin term, complicated words. Are they doing the same work as your regular employees? If they are, they're employees, even if you call them the man in the moon. It's a functional test. That's the ABC test. I've already told you what our test is. Historically, workers brought tools to work. That doesn't make them entrepreneurs. Personal vehicle is also a fungible vehicle. In fact, in the United States, you need it. You're in Los Angeles and you don't have a car, you're a non-entity. You don't exist. You don't exist. It's an enormous city. They have no public transportation to speak of. You have to have your car. And what are you going to do? Stop your car before you get to the plant? No, you bring the car to the plant. The employer wants you to bring the car to the plant. The employer wants you out of there after hours. That is not a capital investment. Now, the user company can do things that makes it hard for you to use the car for personal use, and that may be a different kind of case. That's evidence, by the way, that the employer is controlling how you work under the restatement. Those who make non-fungible investments. You're running an office. You've purchased equipment, up-to-date equipment, Nexus, ChatGPT. Any lawyer who uses ChatGPT, including you, my friend, should be disbarred by the Bar Association, really. ChatGPT is very good if you want to say, what are the best restaurants in Sao Paulo, in this region? ChatGPT could aggregate all the public information. That's fine. And save you from buying all these maps too, in these brochures. But if you're using ChatGPT for mental work, it's going to show. It's going to show. So a good friend of mine is a federal judge in Manhattan, and the lawyer wrote briefs using ChatGPT, and it looked like professional cases that he actually had. The judge said, show me the cases, because the other side said, these cases don't exist. ChatGPT will hallucinate and make up cases for you that don't exist. So the lawyers on the other side said they don't exist. And the judge said, well, show me these cases that you cited. He brings in the cases. They look just like court opinions. They had the stamp of the court. But it's one big fraud. Now, this judge let him off very lightly. I would have disbarred him forever, because a stupid lawyer is worse than an unethical lawyer. Just a sheer stupid lawyer. You understand? You don't use ChatGPT for, now, if you want them to start your paragraph, but it's going to sound stilted, by the way. You're going to use them to sound your paragraph. I mean, who knows? I met with, last night with a spouse of one of the judges here, who is the head of the AI at a major company. I say, what is AI doing? Because I want to know if AI was actually supervising the employees, deciding on the hiring of the employee. He says not. I don't know. There's a lot of noise. I've had 4 conferences in the United States with the heads of human resources to find out how they're using AI. It's like a trade secret. They won't tell me how they're using it. I just don't know. I can see you now get 1,000, 100,000 resumes over the transom. It makes sense to use AI there, so that it may open up your view. So instead of just hiring Harvard Business School or Sao Paulo Business School or IE in Madrid, you're more open. AI may open you up a little bit, but not to make the actual decision. Okay, I'm running out of time. All right, so I already told you the advantages. That's all I'm going to say to you right now. So the idea is, look to your own strength, gig workers. Scare the hell out of Sao Paulo business. You'll get changes.
Professor Stretcher, thank you for your brilliant presentation. Now, Professor Zipper, for your remarks.
Andre, we need to hear from you now.
You do? First of all, thank you so much. Thanks so much for inviting me. Thank you so much for letting me talking to you today, especially Professor Freitas. Thank you so much. Thanks so much, Adriana, for all your work, your hard work, all your worries. The job you're doing is brilliant for having us here. Professor, I don't have any cigar, but I bought some, I bought a gift. Yeah. It's a chocolate made of made in Amazon with Amazon fruits. Yeah, it's not a cigar, but yeah, it tastes as good as well. And well, thank you so much for having me here. And we got to know yesterday at at our dinner, Mr. Samuel and his lovely wife. So it was a very pleasant and a very satisfying moment. We have to hear those bossa nova and that was brilliant. Yeah, the whole thing. And but thank you so much. The point now, first of talking about the appointments that was made by Professor Samuel. There's something that I always used to say. We here in Brazil, we have this moment of labor law is probably, not probably, but for sure, the moment of the most changes since 1943, where we got our labor law code. It's like the moment, is the moment on time that we got the most changes ever since. And why is that? Because we have the perfect storm. We have like three different moments that got together, and they make the perfect storm. First of all, was in 2017 we got labor law reform that changed it, first time ever, 100 articles of our labor law code, more than 250 points of our labor law, which is a major reform, major change on our labor law. So this, especially that put us back to the academy to study what it was changing, and this is the first time ever that I was graduating the last century, and I always say that half of the labor law I learned, half of that was repealed, and the other half I forgot. So that's the point. We have we don't have the distance necessary to find out how we're going to interpret it. The new relationships. We're living it now. So we said yes. Someone said it yesterday. We're like changing the four wheels with the cars running. So we don't have a time because we're living it now. We don't know if this conclusion that we're having it right now in 10 or 20 or 15 or 30 years, it will be considered as like a bullshit, or maybe something that was clever. And that's the point. The second thing that happened, along with the national labor reform, was COVID-19, and because of that, COVID-19, we had the labor, we call the emergency labor law, and the laws was issued at 1 a.m. So we spent like the whole late night discussing in the WhatsApp groups how we're going to interpret these new laws. And so we have quite a lot of new stuff going on. And the third thing that got together with the other two was technology along with work. So we have now digital platforms, we have now algorithm, we have now artificial intelligence, which is things that we have to interpret like every day. And every day is something new. We still don't have any conclusion about crowd work. We don't have any conclusion about crowdsourcing. We don't have any conclusions about platform work. And when you're going to interpret that, what will happen, that they're going to be useless because maybe we have autonomous cars. We won't even have any drivers anymore, or any delivery people anymore. So we are always running after things we don't understand. This is what is happening. So there's a lot of stuff going on. We have to interpret it right now. So after that, it's not we don't have any comfort we had before, because we got like the old books and read the old book, read the old books, and what we read in the old books that were considered like absolute truth, and we don't have any absolute truth right now. And this is why events like this one we are taking place right now, and that's why they're so important. That's why they're so important, because this is why it's so important. We have here like prosecutors, we have here judges, we have here academic people, we have here lawyers, because we have to listen to everyone. If you events that only invite people who think the same way, they don't aggregate, they don't have any things to add to any conclusion, because everyone thinks the same way. And this is why it's so important. About Mr. Professor Samuel just had said, I wrote something to try to bring those ideas to the Brazilian reality, especially here, because we don't have any. We have like a big difference in the Brazilian system and the American system. We can say Brazilian system and all the rest of the world system, because here in Brazil we have this single union system. So it's like only one union. Yeah, China, yeah, and Cuba. So yeah, China, Cuba, and Brazil. So we have this single union system, and most of what was said, we don't have to worry. But we don't have to worry not for a good reason, but we don't have to worry for a bad reason. But we have because we have the single union system, which is a terrible system that was issued during the labor law code, which is like issued in 1943. It was about time to change, and most of what was said maybe does not apply here because of the single union system, which is pretty much communist, and it was so called by many, but it was overruled, but which is used to be called like a fascist system, because it was, we know it wasn't, but many people say it was inspired by the Italian one in 1943, but we actually know it's not. And I would say it's more like a communist one, because of China and Cuba. They have the single union system. About the gig workers possess the capacity to engage in collective action without contravening antitrust statutes, contingent upon elucidation of pertinent legal principle and empirical observations. First and foremost, it is crucial to delineate the primary objectives underpinning the antitrust legislation. Antitrust let's start again. Antitrust laws aim to safeguard the competitive market dynamics by prohibiting anti-competitive practices that impede free trade and consumer welfare. However, they are not intended to inhibit legitimate collective bargaining activities aimed at enhancing workers' rights and improving labor conditions. Indeed, antitrust jurisprudence, as interpreted by courts, recognize the inherent distinctions between concert actions designated to enhance labor standards and those who geared towards suppressing market competition. That was said at last by Professor Samuel. The power asymmetry often preludes meaningful negotiations between gig workers and platform operators, thereby necessitating collective action as a mechanism of redress grievances and advanced share interests. Consequently, the prohibition of collective actions among gig workers under the guise of antitrust enforcement would perpetuate the marginalization of vulnerable labor segments and undermine the overreaching objective of labor regulation. We just hear about the Sherman Act, Antitrust Act, crafted by in response of mounting concerns of monopolistic practices and market distortions, remains a cornerstone of antitrust jurisprudence. Section 1 of Sherman Act prohibits contracts, combination, conspiracies in restraining of trade, while Section 2 prohibits monopolization or attempts to monopolize any part of interests of interstate commerce. This statute has been invoked in various contexts to challenge anti-competitive conduct, including price-fixing agreements and collusion among competitors. Is that right? I'm saying, I just said it's right. Yeah, okay, yeah. That's, yeah, responsibility. Similarly, the Clayton Antitrust Act complements the Sherman Act by addressing additional forms of competitive behavior and reinforcing the regulatory framework governing corporate conduct. And notably, Section 7 of Clayton Act prohibits mergers of acquisitions that may substantially lessen competition and tend to create a monopoly. This provision seeks to preserve market competitiveness by scrutinizing the potential anti-competitive effects of corporate consolidation and vertical integration. However, we're talking here not about like different companies. Even if the workers here, like the Brazilian legislation, can be considered like a micro companies, because I mean, at the end of the day, they're really we consider them as workers, not like a legal entity. And when we read those, all the Sherman Act, the Clayton Antitrust, for us, the LaGuardia Act, Norris LaGuardia Act, even like for us, I mean, the liberal and conservative concepts here, they are changed. We consider liberal what you consider conservative. So yeah, in Brazil is they swap places. And sorry? No. In general, yeah. Even if we take more like we say liberal concepts, in the end of the day, all of them are considered workers, and they're not what we had to stimulate are not competition among them, but they had to get together to become like a bigger force to address their interests against the company. And that's the big difference when we say like antitrust. By recognizing the interest imbalances within the gig economy and affirming the legitimacy of collective bargaining as a fundamental right, policymakers and adjudicators can reconcile the imperatives of antitrust enforcement with the imperatives of labor protection, thereby fostering a more equitable and inclusive regulatory framework conducive to the realization of social justice. We don't even talking about market. We are talking about like people getting together to defend their own interests against like a bigger and a stronger part that is like the company part. We're on this morning, I was in a debate with the Uber lawyer in the Brazilian Bar Association. It was a very interesting debate because we are saying about the differences that we have now with the industrial workers system that was prevalent in the last century. And it actually changed most of the things, most of the concept we had from the traditional labor law, especially because those workers then can engage the platform in 6 different kinds of engagements. They can be engaged or not engaged. They can be online and not online, and they can be active in a call and inactive. So this changes everything. This changes like what we call the time they're working or not. You just said that because like a Prop 22 on California says that the only time that can count on work time is the one that they are active in a call. This is Prop 22. But if you take the like in the UK, the decision of against the Uber, which is they consider those kind of a relation as a worker, not an employee and not a self-employed worker. They consider like the whole time they are online as a working time. So this is not regulated. Even like the bill 12 2024 bill 12 2024, which is a bill like a very recent bill that aimed to regulate platform work, transport platform work here in Brazil, which is being voted by the 2 chambers here. First of all, by the deputy chamber here. And it considers working time only the time they're like engaged, they're online, not all the time online, but the time they're engaged on a call, like the time they accept the call to the time they deliver the passenger. This will be considered like a working time. And even if you take like the legislation around the world, like Chile, around Colombia, all the countries that have legislation, Chile, Colombia, Portugal, the Prop 22, I mean, they're all different from each other. And why is that? Because of, if you consider all the time online as a working time, the problem is that the worker can be online on more than 2 different platforms. So one platform will pay for the time they're working for the other. So they may consider that like they may consider to demand that this worker cannot to forbid the worker to work for some other platform, which they don't want it, which is the thing that they don't accept it, they don't want it, and for all the difference we have, like under European legislation and the American legislation, especially all the bonuses and all the wages, the different wages that like they have to pay there and they have to pay here. It's not that simple just to transplant a decision of a court or maybe a bill or a law from one system to the other system. And you have to interpret it, and you have to adequate to what is going on in one's country. So, of course, it's like it is super important to check what is going on in other countries. But even if you take like global south characteristics, and if you take global north characteristics, in global north, this crowd work, this not a crowd work, but the crowdsourcing, the platform work, the characteristics of that, there is a work that is mostly for immigrants, especially sometimes illegal immigrants, that they don't have spaces on the formal work, and they are forced to engage like platform work, especially deliver. I mean, there even have people like TV shows. They in the US they always do like jokes about you going to an Uber and there isn't like an Indian or a Pakistani driving it, because it's like a characteristic of this is different from here, from what is global south, what is so-called global south. In the global south, it's not for immigrants, that people that come overseas and don't find any job, don't find any find a way to have like money to survive. It's mostly like young people that don't have any education, proper education. It's like mostly young people that don't have any or don't find jobs at the market. Here in Brazil, we have only 29% of the whole workforce under the law. Only 29%. 71% of the whole workforce are not under the umbrella of the law, of the labor code law. So it's kind of hard. There's no space for everyone. I always say that the umbrella, you have to do two stuff. Or you put some everyone under the umbrella, but there is no space for everyone. Or you take this umbrella and you make it bigger. And there's two ways to make it bigger. First of all, you increase the economy. You put the economy better. And like in American legislation in the US, it's quite easy to dismissal, but it's quite easy to hire someone. So depending on the economy, how the economy is growing, like here is like most like zero unemployment under Biden's. But during 2008, I was in America in 2008, and it was like chaos because of the crisis. And but it changes like easily because of the like hiring, dismissal, how easy that is. And here is much more hard to have a dismissal of someone. And this is why those people that don't find their places, their spots on the formal jobs, on the formal activities, because they right, thank you. They try to reach those jobs because of it's so easy to engage. You just need to have a driver license, and then you make your engage it, like taking pictures of the driver license, and you were there. And this is what kind of hard for labor law to find a way to protect those people and properly protect those people, but not to kill the economy model that can actually be useful for someone who doesn't find any other spot on the formal market. And this is what it's so hard. So it's so important, like events like this one that we are taking place right now, to discuss and bring these discussions to life. And we to finish, I think it's the great challenge is to interpret this new relation, not looking backwards, but looking onwards. When we look backwards, it's like putting the, the rounded part, that toy that you put like a rounded part on the square. Yeah, you have to put under the square hole. And when you look backwards, it's something like put the rounded piece on the square hole. And because you don't, you can find something that is adequate to these new relations. So this is the biggest challenge, to find out what is new, and not to think with the old, people like to interpret law on the 1940s. We have to look onwards, and maybe it's not our generation that going to achieve that. Maybe it's the next generation. I always say our task is not to ruin that. We have to deliver, like track and field. We have to deliver to the next generation, like my son, 12-year-old son, that was born with the mobile on his hand, that maybe he or your son, maybe them could interpret this new relation with like a fresh head and fresh ideas, not us that had this idea that was forged like in the last century. I thank everyone. Thank you, Mr. Samuel. Thank you, Carol. Thank you, Mr. Freitas, Ms. Calvo. I congratulate everyone. It's a very important moment, and we must talk, right or wrong. We always find out something that maybe we never had to imagine before. And this is why it's so important. And this is why it's so important to have all these professors. They have like fresh ideas, new ideas, and to share with us. I hope everyone got some new insights from what we discussed here yesterday and today, and that you leave that door knowing more than you know when you got in, right? Thank you so much.
Thank you for words, Professor Zipper. Now I declare the closure of this panel, and once again, thank you the speakers and everyone present.
We're We're going to have a short break of 5 minutes, and then we'll continue our seminar with the final session. And we're going to have 6 professors, and it's going to be very interesting, so stay with us. Hello, everyone. Please be welcome to our last session of the day. We'd like to invite to compose the session Mr. Freitas from Universidade de São Paulo, Mr. Samuel Streicher for NYU Law School, Mr. Vina Dubol from University of California at Irvine, Mr. August Bonner Cochran from Agnes Scott College, Mr. Mohammed Elaine from University of Oregon, and Mrs. Adriana Calvo from University of São Paulo.
And also Professor.
I'm so sorry.
Second.
Professor João Renda from UERJ.
UERJ University. Rio de Janeiro State University. Well, before leaving to each one the floor, I just would like to again thank to the very brilliant presentations we have we could listen to in this 2 days of hard work that we had here. It was not only great presentations, but they were very stimulating in such a challenging subject as regulating gig economy, and especially regulating work intermediate by platform. Well, the idea of this final session is just to give the opportunity for the presenters to wrap up some of the ideas, some of the reflections they could develop in this meeting, in this 2-day meeting, and also to try to draw a picture that they have in mind, what tend to be the next environment of the labor relations, provided that we are facing an increasing rate of precariousness in the labor market, providing also we are facing a lot of changes, a lot of radical changes in the way labor market and labor relations have been established so far. So, do you want to start, Professor? You want to be yes, you will be the first one to. So I leave the floor, Professor August Cochran. Just go ahead for about 10 minutes, but not so rigidly. Thank you. Take this one.
This is better.
Okay. Take this one over there.
One or the other. So thank you very much for your attendance and your interest. It's been very interesting for me. I've learned a lot. I've met a lot of people. It's been a real pleasure for me. And thank you for the organizers for this fantastic event. Just to pick up on several things that I heard that interest me from various speakers. I'm not sure this amounts to a very coherent or organized summary position or final conclusion, but just some ideas that struck me along the way. One, when Professor Sam was talking about self-help and not waiting for the law, this really resonates with me as a political scientist and what I said in my lecture. I think we're at a point of gridlock in the United States. I think we're about to have a very nasty election. I'm not sure who will win, but I'm pretty sure it'll be close either way, and I doubt if any gridlock gets broken by this election. Political scientists are notoriously bad in making predictions, but I don't see it. And so I think that's a very important point, that maybe we, at least in the short run, need to think about solutions that go beyond changing laws. And if I knew more about the Brazilian political situation, maybe I'd be more confident in saying that perhaps you also at a somewhat of an impasse and not at a very propitious moment to think about solving things through legislation, although depends on maybe the situation that Professor Adriana talked about yesterday. Second point that I heard that related to what I was saying is that I was very interested in the California situation as described by Professor Catherine Fisk, really interested in the Olson v. California Ninth Circuit decision, which I really don't know much about, but sounded a lot to me like rolling back the New Deal general approach to legislation and prioritizing economic rights again in a way that we haven't seen since the Lochner era. I'm not sure that's accurate, given that I haven't really read that decision or read a lot about it, but it just struck me as resonating with that point of view. I also would like to emphasize what she said and also what Professor Sam said about California. Being from Georgia, it's really important to recognize that the states in the United States vary radically in their approach to labor relations and employment law. I'm going to repeat a joke that John Henda and I heard from a labor lawyer in Georgia who said, when labor lawyers in Georgia die, they don't want to go to heaven. They want to go to California. So, yeah, typical line. So I think that's worth knowing. In other words, maybe one strategy is to look for those jurisdictions where legal changes are possible, even if they're not possible at the national level or in many of the states. But in many other places, there would be a chance that not only to pass laws that would have an impact, but maybe laws that could serve as Louis Brandeis said states could be laboratories to experiment, and we might learn what laws work and what laws have what flaws by legislating at that level. I wanted to pick up on something that Elizabeth Tippett said at the opening remark too, also, because during this we've talked a little bit about how many gig workers like gig work, and we've heard that there are positive sides about that, and to some extent it represents choices, especially flexibility, I think. And I think that's a valid point and one that's worth remembering, especially when sort of legislating general solutions. But choice always depends on what the menu is. And unfortunately, the menu for many gig workers, I think, is quite limited, and their choices, therefore, are quite limited. And what Professor Tippett reminded us of is that the social benefits in the United States, especially healthcare insurance, are quite erratic, or I'm not sure what to say, chaotic, complex. Anybody who's had a sick relative in the United States has some appreciation of what a mess our system is. And that forces people to make choices about their employment, since so many of these benefits are tied to employment. I think Orly LaBelle long ago suggested that maybe one way to deal with the lack of benefits for people who are not classified as employees is make more benefits based on citizenship rather than employment. I would like to hear more and explore more about cooperatives and the potential for cooperatives. I know it was mentioned at one panel that that's a very difficult path, that there are many barriers. I think it's worth trying to identify what the obstacles are and what possible solutions might be, because I think that is a type of organization that might blend some of the protections that are lacking and some of the dealing with some of the inequalities that are currently so serious, and yet preserving choice, autonomy, et cetera. And then last, I want to mention Professor Zipper closed by saying we should look to the future. And in one of his questions, he talked about self-driving cars. And I just had been talking a week ago with a young man here who's working for Brazilian American combination, and they're working on vertical cars that take off and then fly rather than go along roads. And this sounds sort of utopian, perhaps dystopian, but they're talking about introducing that in 2 years in Great Britain, and that would be with pilots, and without pilots in 6 years. So the future is here, and it's worth thinking about, I think. Thank you.
Thank you, Professor Gus. I got it. And yes, can I ask Professor Mohammed then to leave the floor?
Thank you everyone for being here today, and I would love to thank Professor Freitas and Professor Adriana for organizing this beautiful event. And it's an honor to share the panel with expertise like what we have here, which also makes it very hard for me to talk after our speakers. But I would like to start from where Professor Gus ended, and I think it's a good segue. Okay, it's a good segue to what I wanted to talk about. We often talk about current problems and how courts interact with it, or how the legal community interact with it. But sometimes we often don't pay attention to the future. And I feel like sometimes we have like a crisis management approach instead of a proactive approach. And I think one of the main things that we should talk more about is to how to predict what will happen in the future, and try to prepare us and prepare the people who work in that industry to deal with it. So for instance, I was reading an article, statement from the Minister of Labor here in Brazil, Mr. Marinho. I don't know if I'm pronouncing his name correctly. The Minister of Labor in Brazil, Marinho, yes, yeah. And he was talking about Uber and how Uber, basically if Uber is I don't want to butcher his statement, but he says something about if Uber is not happy with the decision here, Uber can basically, it's Uber's problem and Uber can leave. But it's not just about Uber. Uber is just a name of a company that started a type of business now, but there will be more Ubers in the future. Uber is just what's happening now. But also Uber and other companies helped hiring 1.7 million Brazilians and fill the gap in the economy. So if Uber leaves, that we need to think about how that will affect other innovators and other companies who want start new business ideas in Brazil. So I think thinking about opening dialogue between the government and corporations, how to provide good environment where workers can find these gig opportunities and find like a second income, or even sometimes the sole income that they have, something that can encourage people to take these jobs. At the same time, encourage inventors and the companies to come to Brazil and other countries to innovate and start new businesses. Maybe there is something the government can help here. So instead of, again, the crisis management approach, we're trying to solve problem that already exists, how to think about how in the future, what will happen and how to predict that, and how to work hand in hand with the companies. One thing also I came across recently was after a decision from Brazilian court last year about how that Uber should consider their drivers as employees, and how the reaction of the drivers that they actually were not happy with that decision. So I came across a poll that asked about 2,700 drivers, and 75% of them said we don't want to actually be treated as drivers. Sorry, we don't want to be treated as employees. They like the flexibility that they have. They like the structure that they have. They just want fairness, and you just want a better treatment than what they have right now. So it seems like there is a gap also between the drivers and the workers that we are trying to protect, and the court system and the legal community. This gap needs to be filled by more dialogue between those who are affected by these products or these companies and the legal community. And I think this dialogue can resolve these issues and can basically help us to focus more on what these drivers and what these workers need. Well, thank you again for hosting me. It's an honor to share the panel with expertise like what we have here. Thank you all.
Thank you, Professor Mohammed. Next one, I think, should be Professor Vina. Can I leave you the floor now? Ready?
Sure, yeah. So again, apologies for not being there in person. It sounds like it's been a really fantastic 2 days. I was happy to be able to participate this morning, and I'm grateful to Professor Freitas and to Adriana Calvo for the invitation. I guess I'll start by just giving a little bit of background that I didn't give this morning that can help to frame my closing thoughts, which is that when I first started studying what is called now platform work or gig work, but really is just work, I was in San Francisco, where I'm speaking to you now, the home of these companies, and I was actually studying taxi workers. And my initial response to the advent of these companies was that they were going to go away. I thought surely no one was going to get into an unmarked vehicle with an unregistered driver. Surely no one was going to order their food and have someone else who didn't have any kind of registration with food safety officials have them deliver their food. I was wrong about that. My second thought was, well, this isn't any different than traditional taxi work or food delivery work. And there is a real fetishization, a technological fetishization that is making regulators think about this differently. I was both wrong and right about that. I was right that this continues to be taxi work, this continues to be food delivery work, this continues to be care work. But I was wrong that this was fundamentally different from a labor management and labor discipline perspective. So what I found over the last 10 years of doing a deep ethnography of platform workers, of the legal environment in the US and abroad, and how these platform workers labor and how platform firms are required to make certain shifts in how they do their work, to offer business or not offer business. What I've learned is that essentially this has become a site of extraordinary labor experimentation. And so it is no longer just platform workers who are hired via an app. It is no longer platform workers that are just disciplined by algorithmic management. It is no longer just platform workers or gig workers that are paid through AI systems that determine precisely how much they may be willing to take home or not. It is workers far beyond this sector. And so when we talk about the regulation of gig work, I think it's really critical that we talk about how all of these practices, the labor discipline practices, are not endemic to the platform itself, but actually now go well beyond it. And so what kind of future of the service economy, what kind of future of work do we want to see both in the US and in Brazil and elsewhere? I think the two most salient, discursive and powerful narratives that have been central in preventing the extension of existing employment and labor law regulations to these sectors are flexibility and independence. And I've shown in my own work that the methodology of the surveys that you have seen all over the world, many of them company sponsored, regarding how the workers feel about employment status, are often flawed. And I've shown through my own research that it is true, if you ask workers whether they want employment status, many of them will say no, because no one wants a boss. I don't want a boss. You don't want a boss. That's why we're in the academy. But if you ask them whether they want to be paid for all the time that they labor, whether they want unemployment insurance if they're laid off through any fault of their own, if they want workers' compensation if they're injured on the job, if they want the right to collectively bargain and form a union, an independent union, then they're going to say yes. And so I direct you to my own research in that regard. It is possible, as I and others have shown, from Jeremias Prassel to Valerio De Stefano to Benjamin Sachs, to most recently Guy Davidoff in Israel, it is possible to have both flexibility in low-wage work and to have the kind of employment protections that we have. In California, we have a good documented study done by Julie Shore and her team that showed a company who moved from a platform company that moved from independent contractor status to employment status after the passage of AB 5 in California, and those workers maintained their scheduling flexibility. And the company both said that this ended up being good for them because they were able to retain workers instead of having workers, come and go. And the workers said that they were obviously able to benefit from the protection. So that's also been published. I can direct you to that. Finally, I'll say that the third category of worker, which, first passed in California with regard to platform work and has now spread to Washington State, has the potential to spread to Massachusetts. Or we have taken a state-by-state approach to going to progressive areas and trying to to extend worker protections to these workers. And we've been faced with the retrenchment from the companies who spend millions of dollars on lawyers and on laws to ensure they have basic benefits. What we've learned is that we have empirical evidence, my work and others, to show that this has not actually changed how these companies operate, and it has not provided work benefits that they need. This is extremely dangerous, some of them more dangerous than police work in the US. It is extremely precarious workers. Workers are no longer able to even predict how much they're going to make in any given day. So again, I think the larger issue that we can point to is not just platform work, but platform work as a site of labor experimentation that is lending itself to larger retrenchment, so that we have rights and employer obligations that are being further and further eroded, not just, again, in this sector, but in broader sectors. So in California, after we had Proposition 22 pass, we also had another initiative introduced the very next year that said if healthcare workers, if nurses, if porters, if they were getting their work through a platform, then they too were going to be subject to a third category law. And so where does that end? We got that law pooled, but another version of it just recently passed in the state of Colorado. I'll say that the European Union has been a model for moving forward. So very much unlike the United States, the European Union has passed a platform work directive that makes it clear that many of the workers across the platform work sectors are in fact employees. And then it did a really interesting thing. The European Union has actually grown the rights that workers in this sector have, regardless of their employment status. They now have, once the member states, pass laws to reflect what the directive says, these workforces will now have algorithmic management rights that no other workers have, that are far more extensive than GDPR, and that are far more extensive than sort of localized laws, except for maybe the example of Spain. And so I'll say that I think rather than go the third category route, I think the platform work directive in the EU is very promising. I think that's that recognizing that these workers need the same protections, same social safety net benefits as every other worker is going to be critical, not just for these vulnerable workforces, but for securing good, safe, stable work across the low-wage economy. And I'll end that there. And thank you again for having me.
We thank you so much. Well, I think it could be the next one.
Okay. First of all, I think there can be too much regulation of labor markets. I believe in jobs. My father was a factory worker, low skill. He was able to provide for his family. And this, I don't know Brazil is a great place, but I read in this German report, IZA, that 35% of the GDP is informal work. And I hear from Andre, it's much larger. You have also the various communities. I think flexibility done the right way in labor markets is a good thing because jobs are important. Whether you think they're low value and low, it's part of human dignity. And so flexibility, I don't mean the worst kind of flexibility, but flexibility is important. Germany has a great labor system, but it has a very serious youth unemployment, which I have studied. You make it hard to fire workers, you're going to get hiring aversion, which is what we have in many of the EU states. EU states are in love with regulation. Many of it is unenforceable, their regulations. I'm not sure it's a model for all economies. So I'm a little bit skeptical. The EU directive, there's a directive that says you have to be told, for example, if there's an AI being used with respect to your employment, and you have a right to object there, which is nonsense. No worker is going to object to that. And it's very hard to bring affirmative lawsuits of that type in the EU states. Spain has a serious unemployment. I see even on a Tuesday when you would expect people to be working, they're not working. So I think that has to be factored in. Gig work, if it's opening up, I know that we pro-regulation types abhor gig work, but if it's enabling people to have a job, and Liz says that it's a limited choice, I think things can be done to improve the circumstances of gig work. In New York, we now have a black car fund. And in fact, Uber and Lyft take it out of each time you take an Uber Lyft, it goes into the black car fund, which is a fund for workers' compensation. And more can be done along those lines. Don't poo-poo it because it's not the great big state providing stuff. Medical care is provided by employers in the United States, not because they're required to, because these companies want to. So it's not employment-based, and Org Global is wrong about that. I think something can be done with healthcare. We have Affordable Care Act. Maybe more can be done so that it's more available to people and can be done irrespective of whether they're gig workers or not. There is a problem with the classification system, which I mentioned. If you're actually doing the same work as regular employees, you should be treated as an employee. But gig work allows people to set their own timing. And one of the things that slave labor was all about, wage labor was all about, is they control your day. Well, you're not controlling the day of these people, and they're able to break through the credentialism barrier of a place like Brazil, where everyone's going to get another higher degree. I think there's something to be said for opening up flexibility. I know I know very little about the Brazilian economy, but as I say, I did read in the ICA report that it's the informal labor market is 35% of GDP. Andre tells me it's even larger than that. They can't all be managers, Andre. I don't think that's feasible economy. Everyone is a self-employed, true entrepreneur. It's that there are barriers to employment in this country, and there are fewer barriers in the United States. Now, there may not be great jobs, but there can be a path to great jobs over time. And things can be done to improve that. But to poo-poo these jobs because they don't have all the bells and whistles of people who have regular employment in EU states, I think it's a mistake. It's a mistake in how we think about social policy. I think Andre was on this as well. We have to modernize the overtime laws with respect to these gig workers. If we did that, we'd have more user company buy-in to employee status. So we got to think smart. It's not the 30s, 40s, 50s, and 60s when you had 4 producers in the United States building cars, 4 producers on the rubber And the union was able to organize the entire group. And you basically had an insulated competitive world. We were not affected by international competition. It's just not the same. The South has almost all the new employment in the United States, not the North, not the Northeast cities. California, I told you, is a very special place. Everyone wants to live in California. Everyone wants to work in California. Everyone wants to be fired in California. I don't know how long this will go. Everyone wants to be a labor lawyer in California. It's a very special place. The other states don't have that. New York State needs a lot of social infrastructure. You know, in the old days, we had the Erie Canal. We've got all these towns in upstate New York where there isn't serious employment for people. So I'm not saying gig work is the salvation, but we need to be open to changing things. I can't predict the future. I told you, I will tell you what's going to happen in 30 years, as will Andre and Miss Duval will tell you what's going to happen in 30 years. I can't tell you what's going to happen in 30 days, but we need to be open to this breaking down this notion that it's all about social protection. It's about jobs and training people for employment. I have no problem with taking medical assistance out of that, but it's got to be about jobs, and jobs taking people as they are, which means they may have limited skills. They may not have gone to school. We are in a different category. We lawyers, professors, advocates for labor, advocates for men, we're just in a totally different category. We love our work. These people don't love their work. And they're being, you know, they like, if they can get into a gig work that works for them, they stay there. And I haven't done surveys, but I do my own informal surveys. I've spoken to over 100 Uber, Lyft, and ordinary taxi cab drivers. They like the fact that they have their own work. Now, obviously, they like the fact they can get $80,000 for some other job, which they can never get. Never get. The important thing is you allow them to work and build a steady family. Don't poo-poo that. Unemployment is, I mean, I'm told that the official unemployment rate here is 8%. It's got to be higher than that. We're only counting people that are actively seeking work. I mean, I'm going to rely on you for the statistics, but we have all these communities that are not part of the active labor market here in Brazil, and they need to be opened up for them if we want stability in Brazil, if we want stability in the United States. Anyway, that's where I'm coming from. Jobs. I was once told this was false consciousness. I should be thinking about wages. I'm thinking about jobs.
Thank you so much, Professor Samuel Streicher. So, well, good afternoon, everyone. It's a pleasure to talk again to you. And first of all, I think I must congratulate Professor Calvo and Professor Freitas and also Professor Tippett for this wonderful event. Well, in so many aspects, I think the technical aspect, it's so hard to have so many people at the same time in a hybrid event. I think it was like 4 or 5 a.m. in Oregon when Professor Tippett spoke yesterday. Like the social events, also amazing. And I think I'm learning some diplomatic skills with Professor Calvo and with Professor Freitas. The way you receive foreigners, I also appreciate. And it was a fantastic academic event. I learned a lot. And when I teach, I usually tell my students that there are only 2 expenses that make you richer. It's studying and traveling. And I think that this event made us travel and study at the same time. And when we can gather both of them, it's really fantastic. We have a very famous popular song in Brazil called Suddenly California. It's De Repente California from a pop singer called Lulu Santos. And it's so interesting that we can learn a lot with this Latin American soap opera that is going on in California about gig work. And it's very interesting because we have a lot of things which are very different, but we have a lot in common. I must say that I have one complaint to Professor Streicher, and it's not only mine, it's of all tall people. And I checked actually 3 tall people that made the difference. And I can also name Professor Calvo, but Charles de Gaulle from France in the Second World War, FDR, and I could mention Don Peter II, the guy who created this law school in Brazil. And but it was an amazing event and to exchange ideas. And it reminds me of Ginsburg's friendship with Scalia, because sometimes we can think and we can have different perspectives. I think I have a different perspective comparing to Professor Streicher, for example. I think we cannot talk only about creating jobs. We must talk about creating good jobs and jobs of quality, jobs with dignity. And labor and employment law, they are not enemies of social development, of economic development. And in our labor courts, I see, and I also work as a judge, and gig economy workers, lawsuits are usually all or nothing. And this is a problem, because if they are considered the employees, they will win everything. And if they are not considered, it's nothing. And at the end, if we don't bring some effective social protection, and I don't think the state and the government must be a nanny. No, not a nanny of workers, of employees. But I think we must think about something that really works and that really brings some effective protection, because otherwise, at the end, the state will have to pay like social assistance benefits, and we will have problems. But, and also I saw that, for example, I see a lot of people praising in Brazil the American system of employment at will. It's very easy to fire someone, and it has pros and cons. But people usually talk about the pros. It makes the economy super dynamic. But I was in the US in 2020, and in 12 weeks, in only 12 weeks between March and June of 2020, 43 million new unemployment insurance claims. So there are always 2 sides of the coin, as we say here in Brazil. So I think we should try, and the lawmakers are trying to think about an effective regulation. And I think this seminar was very good to try to bring some new reflections, and also reminding Scalia's and Ginsburg's friendship. I remember there is one episode, and they used to go to the opera together, but I think they traveled to India together, and they went to a ride on an elephant, on the top of an elephant. And both of them amazing. I really like reading their opinions, because both of them really smart. But when they came back from India, people were complaining that RBG left Scalia sitting in the front. And because RBG was a kind of feminist and a lot of stuff about gender discrimination, and they complained a lot about that. And she had to explain it was only about weight balance, a question of weight balance. But it was an event that brought a lot of very good and a lot of new information for me. And I must praise all the organizers and all the professors and all the people that I met here, because I met very interesting people, very interesting colleagues, PhD candidates, master candidates, undergrads. And this talk and all these ideas were fantastic. Thank you very much.
Thank you, Professor John Handa. Thank you all. We are very honored to be able to join this session with all of you, and well, to be able to have you in this seminar. This is sort of the first time we are trying to do something like this. a seminar open, a course, grad study course. So we are going to have some other sessions, obviously, unfortunately, with not all the guests, but some of them will return in different sessions. But, well, I have at this time, on behalf of the organizing committee, to thank you all, to thank you, the audience, to be patient with us. Our technological devices are not quite as good as we wish they were. And well, anyway, it works. At least it worked. And if to be able to give this 2-day sessions challenging possibilities. Well, also on behalf of the Department of Labor Law and Social Security of the University of São Paulo School of Law, we have again the duty and to thank each one of the presenters, each one of the guests. I personally have to, again, to mention especially the fundamental help and aid of our executive director, my dear colleague, Adriana Calvo. Again, my dear friend and colleague, Professor Liz Tippett, just a great friend of ours, and she has, as I told you before, she had already lectured in this room here for 5 days a couple of years ago, and we still have to try again to have Professor Vina Duba with us face to face. Probably it'll be a good opportunity to also bring back to São Paulo and to the University of São Paulo School of Law, my dear friend, Professor Elizabeth Tippett, and each one of you. Well, at this time, I have just to say good night for everybody. Have a good weekend with you in the good weekend.
Thank you.
Thank
very
you.
much.